It is now day 3 of deliberations in the jury for the Kyle Rittenhouse trial. Still no verdict, of course. The jurors were dismissed. They've gone home for the evening. Joining us now, retired State Supreme Court Justice Janine Geske, now a distinguished professor at law at Marquette. So great to have you, Justice. Appreciate your time this afternoon. We were just talking during the break there. Let's get right into it. And of course, as we head into this delay, so to speak, there are some people who thought things would be wrapped up by now. But you said you're not surprised by this. Why?
I'm not. These are complicated issues that the jury is facing in terms of this back and forth, in terms of proving that it was not reasonable self-defense. There are lots of witnesses. There were lots of exhibits they saw. The jury instructions are dense. I mean, in sense of that you really have to take some time with it. And I suspect there are very different views with different jurors on the introduction of this AR-15 into this volatile situation. So I'm not surprised that they're taking a long time trying to talk to each other and convince each other.
I printed out a copy of those jury instructions. It is a dense copy. It's a dense read. You said that you were surprised that the judge allowed the jurors to take that copy home, those 30-some pages. Why are you surprised by that move?
Yeah, I've never heard of a court allowing a jury to do anything at home on a case, and that's really what they're being allowed to do, is to take those instructions. The big risk is that they use some outside source to interpret them, that they either look them up on the internet or they ask somebody about what these words mean, or get input from some other source. I don't understand why you would let jurors individually do that. You really want them in the room together, talking to each other, asking each other questions, and so that they're working on it as a group. I think that was a bad idea.
This continuation, do you think that perhaps this indicates that maybe there is one member of the jury who says, I am just adamant. I am either siding with Rittenhouse and saying, he's not guilty, or maybe, yes, he is guilty, and you juror A, you juror B, aren't going to dissuade me. Do you think that's an indication here?
Could be anything. It could be 6 and 6. Mm-hmm. It could be 9 and 3. There are people that have different views. That's one of the reasons they ask for evidence, is to try to convince each other of what they saw or what they believe the facts are. And so them asking for evidence is a sign that some groups or one person was trying to use it for others. They're obviously working very methodically. From the outside, they're looking like they're doing just exactly what we want them to do. There obviously was not a quick verdict. And so I think the likelihood that it's going to be an all-in-all acquittal would be a surprise.
Yeah, just a couple seconds left. Does the judge have the right to say, knock on the room where it's happening and say, hey, you guys, wrap it up? Or can they take as long as they want on this? I mean, could they take weeks, days?
They can take as long as they want. What usually will happen at some point, and it could happen in the next day or two, that they send out a note saying we're hopelessly deadlocked. We can't reach a verdict. And what happens when that occurs, the judge gives what we call an Allen charge. And he reads this charge to them saying, no other jury is going to be in a better position than you are to decide this case. I'm going to ask you that you go back in and try again. If they don't reach a verdict after that charge and come back deadlocked again, most judges will declare a mistrial at that point. But if they don't say anything, they could stay away for a long time.
Justice Geske, we always appreciate your insight and opinion. Of course, we'll be talking to you again. Thank you for spending time with us this afternoon.
You're welcome.